Poncho knows the subject is contract or copyright. Which one has more power? Which one is most important? Which one is most binding? Your copyright protects you against any verbatim usage. So that means if you find somebody that's using your piece verbatim, because all they got to do is change it by 10% and you will have to argue the originality in court. That is a real situation you got to look at. So the other side of this is a contract. And so oftentimes you'll sign a contract that might have clauses in it that might be restrictive. Make sure you don't agree to certain things in a contract that will override your copyright. The copyright is only for verbatim usage, but the copyright protects you if somebody misuses that image. They have to be held liable for anything they do to violate their copyright. But say, for instance, you got a copyright clause and it says, we want exclusive right. Exclusive right means even over you. That is a sneaky clause that I always challenge in a contract. Never sign an exclusive right contract. Most of your contracts you say non-exclusive right. That means that they can use it, and then you'll outline in the contract the specific use. No, they can't do tickets and underwear with it. They can only use it for a print or a cover or whatever. The more specific you are. Don't go for broad clauses. First right of refusal is another one that will get you. First right of refusal means that if they get the first right to say they're going to publish or manage a piece before you do. And normally you would give a term for first right of refusal. A lot of times I was in contract agreements where I had to send my new creations to this person. They had a certain amount of time to respond, and then if they didn't respond in a certain amount of time, you can bet your last dollar I was going to publish it. That was to hold them to move fast and don't wait on my stuff. That was me also controlling my power by showing them what I am able to do with my own copyrights. But the contract can cause issues down the line. I was once sued, my most popular piece, Black is Black, for $35,000 and lost. The reason I lost is because in the contract that I was given, there were tricky clauses in it that said that the image would transfer to them after a certain time period that I didn't catch. It also had other clauses in the contract that completely overrided my copyright. And even though I had to go to arbitration, so that's not like I went to court, when you see an arbitration clause in a contract, that means you're going to be going into a room with a person that's acting as judge and jury, and it's going to depend on everything you do, whether you do good, whether you do bad. When I got sued for $35,000, I went in mad because they did this to my copy. Oh, they're not going to get away with this. And the person who got away with it just simply was talking about, hey, I started this in my basement, and I work with thousands of artists, and this is what and so they looked at his character versus my character because my disposition was wrong. And I was young. I was in my 20s when this happened. I lost the arbitration case. I had to write a check for $15,000 and pay this person $35,000 off of a copyright that I actually owned. Copyright versus contract. The contract always will prevail. Poncho knows. Peace.